SJC-12907, Commonwealth v. Clifton R. Caldwell.
Thank you. Attorney Kavanaugh. Oh. Maybe we don't quite have everyone. Just hold on for Justice Lowy. Let's see if we can get him on board. Okay, great. Looks like we're all set. Attorney Kavanaugh.
Good morning, Your Honors. Lisa Kavanaugh with the CPCS Innocence Program. It is my privilege to appear before this court on behalf of Clifton Caldwell. The injustice of Mr. Caldwell's conviction hinges on evidence that the jury never heard, that the motion judge committed clear error in analyzing, and that no appellate court has ever before considered about the single most important witness in the Commonwealth's case, George Thompson. The Commonwealth built their entire case against Clifton Caldwell on the worst of the worst kind of evidence, a jailhouse snitch who was not a precipient witness, had no basis to know what really happened, and yet claimed to have the most powerful evidence of all, a direct
Let's
confession.
Stop there for a minute. Why do you characterize the jailhouse snitch as a stronger witness than the victim?
Because every single court that has ever examined this case and the prosecution himself during his closing argument acknowledged as much. I would point—
Now, let me ask you a few questions about the judge's decision.
Yes.
What standard of review do we apply when we review this?
The standard of review, well, first of all, she was not the trial judge in this matter, and so she's not entitled to the special deference.
But you did. There were some evidentiary hearings, though, weren't there?
There were evidentiary hearings. However, the majority of her decision actually turns on her interpretation of written records, and in that regard, this court is in as good a position as she was to evaluate the significance of those written records. And so I would suggest that applying that what I've highlighted and what I will direct my comments to today are the examples of clear error in her analysis of those records, but that this court is in as good a position as she is to examine the records, in particular, all of those relating to George Thompson's extensive criminal record, to his the evidence that he had done this before in the Raincourt case.
That was 15 years past, right?
I apologize, I didn't hear you, Your Honor.
That was 15 years before that trial, the second trial. I mean, but before the Clifton trial.
Yes, it was. He had in a prior case, he had testified. He had obtained a confession under strikingly similar circumstances, and he had testified against that defendant and then gotten a benefit after testifying.
Right. Based on that, was there any evidence of any additional jailhouse confessions in between those 15 years?
No, it's not our contention that Mr. Thompson repeatedly served as a jailhouse snitch. What we're suggesting is the jury would have looked at him quite differently had they understood that he had done this exact thing before on even one prior occasion, because it fundamentally contradicted the way that he talked about himself. And more importantly, it's critical, as the judge failed to do, to analyze the importance of Mr. Thompson's past role as a snitch in the context of all of the other evidence that we presented bearing on his credibility, which includes the fact that he directly lied to the jury about the extent of his own criminal record, telling them he'd been to jail maybe 3 times, when in fact this was a man who had 63 convictions, who had been to jail in 10 different cases. He'd received committed time.
I thought that the judge found that there was an error. It was four times, not 3 times. Is she wrong?
If I will refer to the court to the chart that I included in the record appendix,
Okay.
page RA 380, because that chart lays out that he received committed time in 10 separate cases. I don't actually know, because she doesn't explain, where she comes up with 4 as opposed to 3. It may be that she's looking at, you know, the fact that there were concurrent sentences, but the bottom line is that the jury never learned that that he had 10 convictions for which he had.
So how many did they learn he had? 5,
they learned that the sum total of what they learned about his criminal record was that he had been to jail maybe 3 times for motor vehicle offenses, when in fact he had been to jail many, many more times than that, or at least been sentenced to committed time many, many more times than that, convicted of over 60 crimes, and had received.
And the 60 convictions were before he testified in this case?
The full Corey, and I don't have the exact numbers before me. The full Corey appears at page RA 456, and
so you don't know whether the 60 convictions were before the trial.
The vast majority of them were,
but we don't know the number until I go through and count them. Okay.
Right.
The next question I have is, I'm just really interested in the standard. You say we are in as good a position as the judge to review the documentary evidence. So looking at her findings, where do you say she erred?
I think she erred fundamentally in her overarching legal analysis. So I think there may be individual factual errors that she committed, but the fundamental problem with her decision is that she fails, and there's really two overarching errors. One of them is that she fails, she again and again substitutes her own evaluation of the evidence for that of the jury. So in other words, that it's abundantly clear under the case law that the judge is required in the context of evaluating either materiality or prejudice to assess the probable effect of new evidence on the jury's decision-making. This court recently reiterated that in the Diaz-Lopez case decided earlier this year, but that's a principle that's been well established in the case law. And instead, what she does again and again is to say, essentially, this doesn't persuade me because the way I look at it, it's only relevant for this one little thing. And she never once looks at how a jury might have actually viewed this evidence differently. And I can give the court some examples of what I'm talking about.
I would like that.
The first is that when she's looking at the period of time, so one of the areas of focus in this case was what kind of exposure was George Thompson facing when he first decided to talk to the police? And then in that sort of, period of time leading up to the trial. And then what was he facing when he actually testified? And so when she looks at that period, and she does consider it it appears in our addendum at page 73, she reasons that that the dispositions of his cases in the interim between when he came forward to talk to the police and when he testified at trial, that they weren't credibly related to his cooperation, and therefore wouldn't have made a difference to the jury. And this doesn't consider that what all the jury knew about his exposure at all, at any point during this time from when he met the Caldwells until he testified, all they knew was that, according to him, when he sat down and met with Detective Hayes, he was serving a 6-month sentence. So he had, nothing pending, which was not true. He had multiple cases still pending. So he lied.
But again, we don't know how many.
We do. He had 3 cases pending. That is very clear. And the chart.
That might be where she gets the 4.
Sorry, the 3 versus 4 is a different issue. So when she's speaking of the 3 versus 4, she's talking about the number of times that he was committed to jail. What I'm referring to is how much criminal exposure did he have when he talked to Detective Hayes, when he first decided, I'm going to get myself into this case for whatever reason. And at that point in time, what the jury was told is he was serving a sentence. He had nothing to gain. That was not true. He had 3 pending cases at the time he talked to Detective Hayes, in addition to the one he was serving time for. But the court doesn't think about or analyze how that might have changed the jury's calculation of what was motivating Mr. Thompson.
One thing that's interesting about this particular case is we have 2 previous motions both in front of the trial judge, where the trial judge concluded that, and he seems to make reference to what the jury did hear and didn't hear. So how do we factor in any of the previous trial judges' conclusions in those previous motions, or are they all just irrelevant?
Well, they're not irrelevant, but I think there's 2 points about that. One is that the trial judge committed the same exact error that the motion judge did, which is that he substituted his judgment about whether that information affected his view of George Thompson's credibility. So if you look at his decision, he's saying again and again, I found him to be credible, which isn't the standard. The standard is, did the jury find him credible, or would this information have changed their calculus? The second point I want to make about the trial judge is that he did not know this information. So if you look at, and I think fundamentally this is where this combination of new evidence and ineffective assistance gets really muddled, and you have to pull back and focus on what actual information do we now know that the jury didn't know? Because in the litigation of the new trial motion that focused on trial counsel's ineffectiveness, which, as an aside, was egregious in many respects. If one were to reread the trial transcripts, it is abundantly clear how ill-prepared this trial lawyer was. But putting that aside, the motion judge doesn't receive any of the information that I presented to, sorry, the trial judge doesn't receive any of the information that I presented to the motion judge. He doesn't get the charts, he doesn't get the close analysis of what kind of exposure did he have throughout this time period, how might his motivations have been altered by that exposure. So, and most importantly, he doesn't get the information about what's in the DA note. So fundamentally, we're talking about the prosecutor has known from the moment he talked to George Thompson before putting him on the stand, he knew that George Thompson said, I've done this before. And then I called someone named Todd Canberra, and that's how I got involved in this case. And that information was known to the prosecutor from the moment he put George Thompson on the stand, and yet not disclosed.
Right, so assuming that that should have been disclosed, where is the standard then is prejudice, isn't it?
Yes, and I think regardless of how, whether, because I think there is a confluence of what better prepared counsel could have accomplished, especially when it comes to analyzing and presenting his criminal record and the information that's contained in the Raincourt note. You know, the judge essentially finds that trial counsel could have found out information about Raincourt. Now, I have to say, having prepared many a trial, I'm not sure I've ever done a Westlaw search of a witness. No. So I'm not sure I agree that trial counsel necessarily would have stumbled upon it, but he didn't have to, and he shouldn't have had to, because the prosecutor knew it.
Well, before we go further, just for my benefit to refresh my memory, I think you basically are, you've got, is it correct, I know you've got 3 different theories, but are there also 3 basic pieces of evidence or areas of evidence that we're talking about here?
Yes, with respect to George Thompson, there's really 3 areas. There's the one is that he had done this before and gotten a benefit for it. The other is that in that case, there's evidence that the SJC affirms that he had this relationship with the state police over several years. And we're not contending because we couldn't, but frankly, because by the time we learned this information, any records that might have substantiated his ongoing relationship were gone. And I think that's abundantly clear from the way that—
Well, do we know if they're gone, or do we know that, or do we just don't know? Do we know that documents existed and now they're gone, or do we just not know if there were documents?
We know that the DA's office in Bristol County destroyed their file in the Raincourt case in 2011. So,
but we don't know what was in it.
No, I mean, but we have no way of knowing. And the reason that the defendant is deprived of this information is because of the Brady violation. But
right.
Back to the 3 categories. So we have that he'd done this before, that he had this past relationship. And I think that it's important to keep in mind, yes, the Raincourt case was many years earlier, but we know that that relationship with the state police was maintained because he told the prosecutor. I called Todd Canberra, and that information maybe in a vacuum wouldn't have made a lot of sense, but we were able to determine by looking at his Department of records that Todd Canberra was a state trooper who went to meet with him weeks before he met with a detective in this case. So in other words, we have Thompson himself essentially telling the prosecutor that the state police were a conduit for his connection to this case.
Now, is this part of your number of one category? Is this, okay, that's two.
And then
that's number two.
Yes,
okay.
And then number three is that he lied to the jury directly about the extent of his criminal record and about the extent of his exposure leading up to and during the trial. And I just want to, if I have a moment, I want to.
Before you, just factually, one question.
Yes.
How does he get in the cell? Is there any suggestion that the Commonwealth put him in the cell?
No, there isn't, and I think that's an important distinction between the facts of this case and the facts of Rancourt, because there really was a focus in Rancourt on whether he'd acted as an agent of the Commonwealth, and there's no evidence that that was the case here. It's also significant that in Rancourt there was a written confession, and here there is no such written confession because we contend he never made a confession, and so, but it's very clear that the sort of in that respect. There's no evidence that he was placed in that cell by the police. What there is evidence of is that he had a whole lot more riding on, sort of hanging over his head at the moment when he met the Caldwells at the arraignment and then ended up in custody with them. He had much more riding on it, hanging over his head than he let on to the jury.
Ms. Kavanaugh,
Well, now, go ahead.
Go ahead, Justice Seifert, please.
No, I was just wanted to follow up on that because the motion, so he says he's like, he's impeached he was impeached at trial with evidence that he'd been in jail for about 6 months and had been in jail maybe 3 times for motor vehicle offenses, right?
Yes. Yes.
And I had thought that the difference was actually that he had actually been incarcerated 4 times, right?
Well, that's only part of it, right? I mean, he clearly, the way it's presented to the jury is that's the sum total of his criminal record. As far as they know, he'd not only been to jail 3 times, but he only had 3 convictions. I mean, that's how it comes across to the jury.
Well, why didn't the defense attorney, and you're saying the defense attorney should have found all those other convictions?
Absolutely. I mean, and you can
see they all existed at that time.
How poorly prepared he was from the fact that he didn't have a single certified criminal conviction, so that he wasn't even he was not entitled to a jury instruction on impeachment with prior convictions because he hadn't gotten any. He hadn't followed the steps that are needed to impeach someone with a prior conviction. But I think it's important just to note that why didn't the jury learn this information, these 3 categories of evidence? They didn't learn it because even though we do have some safeguards in place, right? We have a discovery process, so the Commonwealth has obligations to turn over the information that they have. We have defense investigation, which ordinarily would serve some protection. We've got the tools of cross-examination, which a well-prepared lawyer might use to protect against unreliable evidence. And there's jury instructions. Here, every single one of those safeguards failed Mr. Caldwell. The prosecutor didn't disclose the information. Trial counsel didn't learn it on his own. He didn't confront Thompson with it. And the jury instructions did nothing to equip the jury to evaluate his testimony. And I think—
But Ms. Kavanaugh, as you list those, isn't the strongest argument you have by far when we look at standards of review, the failure to turn over exculpatory evidence if there was a specific request, as opposed to going right into the brunt of our case law on what it takes to get a reversal for something lacking in impeachment? Isn't the strongest place to go the failure to turn over exculpatory and that it was a specific request?
I certainly think that's a very strong claim, and it's significant that the judge literally did not address that at all in her decision. She did not speak one word to the Brady standard of review or the basis for granting relief.
But that's your best standard of review, isn't it?
I apologize, I missed the
That's
question.
your best standard of review on it if we're dealing with a specific request, isn't it?
I think that's true. And I also think there was a moment, the Commonwealth contends that there wasn't a specific request, but in fact, I'm not sure how much more specific you can be than to ask for information about, promises, rewards, or inducements. Like how would one ask more specifically, has this person been an informant before? Why would you even—
Sounds like a good way to ask.
Well, I mean, presumably the Commonwealth had a duty, regardless of whether there was a specific request, right? It's talk about the needle in the haystack. But on the issue of whether that's the strongest ground, I also think it's important to note that although the general case law on overturning convictions based on impeachment evidence is not helpful. Here, we're dealing with a case where the impeachment evidence goes to the centerpiece of the Commonwealth's case. And I think it's really important to go back to what the Commonwealth said in closing argument, because they literally start their closing argument by quoting George Thompson. "All I did was hold her down. His words from his mouth to your ears." So they literally put Clifton Caldwell in the witness stand through the mouth of George Thompson. And that is their case against Mr. Caldwell. And again and again.
And also the victim testified, right?
She did, but at the trial of the brothers, 2 weeks later, they were acquitted. So there's no doubt that George Thompson absolutely made or broke their case. And that if the jury had had the information that we now have and had looked at it in the totality, in the way that the motion judge failed to do, that the result, that information would unquestionably have influenced their deliberations in a case that absolutely turned on this one witness. And this one witness, who, as the amicus brief points out, is the most dangerous of all categories of informants. The jailhouse informant is the most dangerous of all. And I did want to point out that unlike all of the other categories of evidence that we know contribute to wrongful
Ms.
conviction.
Kavanaugh, I'm sorry, I'm going to have to cut you off. That's in your brief, right? That last point you're about to make.
Yeah, I would just direct the court to the amicus brief at page 15. Thank you.
Okay, thank you so much. Attorney Burbine.
Yes, may it please the court, Carolyn Burbine for the Commonwealth. We did not build our whole case on George Thompson. We also built it on the victim's testimony, as well as testimony from her mother and her sister, who corroborated much of what she said about her family.
What they corroborate, I mean, I'll be honest, I can't figure out how the brother didn't get convicted, because all of that corroborates that the brother was in the bathtub naked with an erection, right? But it doesn't provide much for this guy. I mean, again, it's sort of shocking that the other person's acquitted, but I'm now presented with this much more complicated case that clearly turns on Thompson, because the witness is really discredited, particularly in regard to Ricky and sort of the brother's role. So I'm confused how we don't think this Thompson testimony is hugely significant.
Well, I'm not saying it's not significant, but I'm saying that we didn't build our whole case on it, as defense counsel has posited. And we, as a matter of fact, we relied heavily on the victim as well. And, you know, the defense is trying to paint her as having false memories, inaccurate memories, and a lot of what her family, sorry.
They've got the fact that she falsely testifies against Ricky on this other episode, right? Even though she knows it's not Ricky. I mean, if this were the brother, I'm totally with you, because I've got independent corroboration of his sexual exploitation of this child. But this is really difficult with this defendant, isn't it? I mean, it's just...
Well, what I think is striking here is the fact that George Thompson's version of what the defendant told him is so close to what the victim testified to. Where else could he have gotten that information? I think that gets lost here in all of this.
Well, isn't the argument that he's got this relationship with these police officers, and he's got an incentive to be helpful, a huge incentive. And why does he need to lie about all this stuff to the jury if he doesn't? I mean, I'm just... Well,
I don't think he did. I mean, the judge here and Judge Connolly before her found that he had testified at the trial that he was incarcerated 3 times. Judge Kelly found actually that he was mistaken, it was 4.
So hold on, so,
Look at Judge
so how many
Connolly.
times, but Ms. Burbine, how many, I mean, I haven't looked at Ms. Kavanaugh's chart yet, but is it actually 10 times? And is it not for motor vehicle, but for breaking and entering and all kinds of more serious offenses?
He had more of a record than his original trial counsel realized, but what's not being acknowledged here is Judge Connolly in his findings and Judge Kelly in hers, noting Judge Connolly's findings. Judge Connolly went through that record and he looked at it and he determined that much of it would not have been admissible because many of those convictions were for misdemeanors and or crimes that you couldn't impeach him on. They didn't go
right?
to
I mean, I'm confused.
credibility. So I dispute.
I'm confused about that. He's not a defendant. He's not a defendant. They can't go through his whole record.
I'm sorry. Well, they were talking about what could you impeach him on, and Judge Connolly went through that record and determined that much of it, and trial counsel did as well.
Even if he lies about his record, they can't say, when he goes and says, I got 3 offenses, they can't literally go, you're a liar, you've got 100 offenses. They can't go through, and they can't go through every single one of them.
The question wasn't offenses, it was how many times have you done jail time? So, and Judge Kelly went through that record that defense counsel presented on this motion, and she found 4 jail terms. So I dispute.
Well, but this is a record issue. We're
That's a record.
gonna do this ourselves. And I take it, is Ms. Kavanaugh's chart all wrong? If it is, let us know. But is it?
I'll go through it, Your Honor.
Well, I don't want you to go through it now, but
No, not now. No, I wouldn't do it now. No, it's huge. But I'd also like to point out, you know, at the beginning of the argument, we talked about the standard of review, and the standard of review is did the judge make an error of law or other abuse of discretion? And it's our position she made no such errors. And then in terms of her findings of fact, her findings of fact have to be accepted if they're supported by the record. And our position is they are, contrary to what my sister has said.
She says there are 3 areas, and it seems to me like all 3 areas are problems for you. And then you've got the 4th area, which Justice Lowy has emphasized, which is we don't turn over the Rangul or Randul stuff. So that's a big deal too, right? You know,
It's Rancourt and
the Rancourt, right? Well, I dispute that the defense actually established that he was a police informant. I mean, they're trying to make out that he's a career police informant. What did he do? He potentially was involved in Rancourt.
he's got a cop spending $1,000 to bail him out of jail.
But he testified in that second hearing that he and La Priori were friends. And the judge here completely discredited everything that Celovich gathered from La Priori. She explicitly discredited it because there was no corroboration. We have no affidavit from La Priori.
Well, Priori is dead at this point, right?
Yes, he's dead. And
you get an affidavit from a dead guy. You know?
He talked to him, and I think 2 months or 3 months later he died. That should have given him time to get an affidavit. And also, the investigator himself acknowledged that he wasn't able to verify anything that La Priori told him. There was no corroboration of what La Priori says. So, and the judge explicitly said, I don't credit.
Was there, excuse me, counsel, was there an affidavit from Celovich, the other investigator?
Yes, there's an affidavit from Celovich, and he testified at the hearing, and he was questioned and cross-examined on this. And the prosecution at the hearing was able to poke big holes in his version. For example, La Priori's, he wrote that La Priori told him that he bailed Thompson out of jail in Pennsylvania. So he looked into that. He couldn't find any record of it. And indeed, when you look at the III and the sheriff's office records. He was never, there's no record of any kind of arrest in Pennsylvania. And when you go through the cross-examination of Celovich on what LaPriori told him, none of it could be corroborated except for one jail slip. And that was the one that was where LaPriori bailed out Thompson. But Thompson had testified at the second motion for new trial that he had been friends with LaPriori for 20 years. That's not the same as I am a snitch for him and I rat people out for him with regularity and he's my handler. I also think that the note, the note, meaning of the note has been, I mean, I don't think that we can tell for certain that that note means that it was George Thompson who called Cambria. It says George Thompson at the top, then it says met all three in Plymouth Hold, then it says Todd Cambria called. I mean, did the prosecutor call Tom Cambria? Did George Thompson call Todd Cambria? That doesn't say George Thompson said he called Todd Cambria. Now it's true that there was a meeting, but then Cambria said when Celovich, the investigator, contacted him, said he didn't recall even meeting with Thompson. And Celovich was asked, did you have any indication that Cambria was Thompson's handler in 1999? Celovich answered, no, I don't have that. So I think the note has been interpreted by the defense, but I'm not sure that, you know, it's a smoking gun that they want it to be.
Well, assume,
I mean, there's no question we should turn it over. I'm sorry?
Well, just assume for the sake of argument that it is exculpatory, Ms. Burbine. Was there a specific request?
It's our position that there was not, that there was a general request.
And can you explain why you don't think it's specific, please?
I would have to look back. I didn't write the brief in the case, Your Honor.
All right. Well, with Chief's permission, maybe you could, with the Chief Justice's permission, maybe you could submit a 16L.
I will do that.
Do you agree, Ms. Burbine, that this is the sort of impeachment evidence that takes us out of the limitation of cumulativeness, where, you know, typically we'll look at a motion for new trial and say, well, this is impeachment evidence is usually cumulative, and so it's usually not going to generate a new trial. Do you agree that this is of a different nature?
I do not, because as defendant's trial counsel testified, he was aware that George Thompson had been involved with the police in the past. So he did look into his record, and he did look into, you know, he had informant that, I'm sorry, I lost my place, that he had some involvement with the police in the past. So he knew enough to look and see if he had been an informant and try to impeach him on, you know, whether he'd ever.
Isn't there a big difference though between having a police involvement in the past and actually having had a situation where he had informed the police in the past about something another defendant did, and then as a result received a benefit for it?
Well, I disagree that in Rancourt he received a benefit, because in that case it explicitly says that while his sentence was cut short by 2.5 months, that was for his protection because he testified against another inmate. It was not a reward for his testimony.
But I mean, he did get out, right? And so that might be something he was hoping would happen again. I mean, I'm just, my only point is that it does appear to be something that a defense attorney would want to be able to look into and inquire on cross.
But he was asked about that, and that's important to note. He was asked repeatedly and aggressively on cross whether he had received any promises, inducements, or rewards, and he was adamant that he had not.
No, you're misunderstanding. I'm sorry, I'm not being clear. He wasn't asked about Rancourt because he didn't know about Rancourt.
No,
right?
but he was asked generally, you know, about that because he had told Detective Hayes that that he had helped the police in the past. And that did put, his trial attorney did say that did put me on notice, although he didn't know about Rancourt. But the whole thing with Rancourt is if Rancourt had come in, let's say they did know about Rancourt and they impeached him about it, our point is that Rancourt would have helped us in terms of his credibility, because he had testified, well, I have a bias against rapists, so the jury heard that, and they had heard that he detested him. He didn't, and that was why he told on Rancourt. Well, that's what he said in our case, the same thing. He had said in Rancourt that he was not promised anything in exchange. And that's what he said in this case. So the jury hears that in the past he testified 15 years ago against a rapist, and that he did so, he was saying now that he did it because he detested rapists. Well, back then he presumably did it for that reason as well. There was a credibility battle between Rancourt and Thompson in Rancourt's trial, where Rancourt said that Thompson had coerced him and threatened his girlfriend, and that was why he gave him the confession, and Thompson denied that, and the trial judge held that it was Thompson who told the truth, not Rancourt. So, I don't see how it would help the defense in this case to hear that was the result of Rancourt, that the SJC had upheld the trial judge's decision that it was Thompson who was credible. So I think that's important to note.
Do you want to address the sort of point made in the MacDill brief that the way we handle these sort of tit for tats is unrealistic, that in these type of confidential informants, there are no promises made until afterwards, so that it's deliberately avoided. You want to address the fact that our jurisprudence on this is unrealistic, and it doesn't really reflect sort of the way this is done out there in the real world, which is you don't make the promises because defense counsel is going to ask this particular question, but rather you provide the benefits after the trial, as they've done here and in other cases. You want to address that point?
Well, here he didn't get any benefit. He testified at that trial, and he had to serve his 6-month sentence on his probation revocation. He did not get any benefit whatsoever.
Talking about the large, but we'll dig into that, whether that's accurate or not. But I'm talking about the larger point they're making, which is our jurisprudence doesn't accurately reflect how these deals are really struck. That
I don't know that it's true that with regularity prosecutors are making deals and then hiding them from defense counsel because
they're not. They're saying that everyone's smarter than that.
I don't handle informants for this office, but I can't believe that that's the normal practice in the DA's office, isn't it?
They do provide a lot of, at least, sort of law review type of stuff. You don't address it. I'm just giving you that opportunity, but I take it you're saying it doesn't happen out there, so we don't have to worry about it.
I want to say that I haven't looked into it, but I don't believe that.
Was any of this raised below? Was any of this raised below in front of the motion judge?
As far as I know, Your Honor, there's nothing in the record on that. So I don't have anything to comment. I mean, I can't really comment on it. I've never done any surveys or studies, but I would find it hard to believe that that's how our offices all operate. It's offensive to me.
All right, does anyone have any further questions? Very well, thank you, counsel. And that will conclude our hearing for today.
Thank you.
Thank you.